Good morning, everyone, and welcome to this edition of the Radcliffe Chambers Junior Programme. My name is Natalie Pratt, and I am the Junior Tenant in Chambers, and I'm joined this morning by my colleague, Matthew Mills. And you join us this morning on a great occasion because this is our first Charities Junior Programme hosted by Chambers. So we're absolutely thrilled that you can join us on this very cold and foggy Friday morning in November. So Matt will be speaking first, and he'll be speaking about the incorporation of charities. I will go second, and I will be discussing how we might go about challenging Commission decisions with a specific focus on judicial review.
Good morning, everyone. As Natalie said, my name is Matt Mills, and I'm here to talk to you about incorporating a charity. In particular, I'm going to talk to you a little bit about the background of my webinar, before turning to the different powers charity trustees might have to incorporate. I'll then talk about the mechanics of incorporating a charity before closing with some practical tips to bear in mind if you have a client considering this. All right, let's take a step back. What do we mean when we refer to an unincorporated charity and an incorporated charity? Unincorporated charities typically refer to either charitable trusts or unincorporated associations. And when we say incorporated charities, we typically refer to either charities which are companies limited by guarantee or charitable incorporated organisations, CIOs. There are technically other options like charities incorporated by Act of Parliament or charities incorporated by Royal Charter. But I don't know about you, but my practice hasn't involved that many applications to the Privy Council office for a Royal Charter, like this one from 1662, which established the Royal Society. But in case your practice is much more glamorous than mine, here is the link you need to follow if your client's considering applying for a Royal Charter. Now, an important point to bear in mind throughout this webinar is what the word incorporation really means. Technically, an existing unincorporated charitable body cannot convert itself into an incorporated body. Instead, in most occasions, when we say incorporation of a charity, what we mean is a charitable trust or unincorporated association wants to transfer all of its assets to an incorporated charity, which is essentially designed to replace it. But moving a little closer to our topic, why am I talking to you about incorporation today? Well, the short answer is that the numbers appear to show that incorporations are on the rise. For example, between March 2017 and March 2019, the number of registered CIOs increased by about 400%, from about 4,500 to about 17,000. However, over the same period, the overall number of charities stayed almost exactly the same. In other words, it appears that the percentage of incorporated charities as a whole is increasing. Similarly, over the last 3 years, the number of registered charity mergers has increased by about a third. And when you flick through the list online, it appears that around 70% of the mergers in the last 12 months have involved a charity being restructured in some way, predominantly converting from an unincorporated charity into an incorporated charity of some form. So why are charity trustees doing this? Well, there are typically said to be two main benefits of incorporating a charity. Firstly, an incorporated charity has legal personality. That means the charity can contract in its own right and be liable for its own debts. So the trustees have less personal exposure because they're not necessarily signing contracts in their own name. This can be particularly important for smaller charities, where the trustees are concerned that the assets of the charity would be insufficient to indemnify them if something went wrong. The second main benefit is that an incorporated charity can own assets itself. In particular, this is very useful for land because it means the trustees don't need to register the land in the name of the official custodian for charities or in their own names and then have to remember to change the name each time a charity leaves it or dies. However, incorporation is not entirely free from trouble. If a charity is registered under the Companies Act, then the trustees will be subject to two sets of regulatory duties, one set under charity law and one set under company law. For example, trustees of companies limited by guarantee must file accounts with both Companies House and the Commission. Secondly, sometimes, as I'll discuss a little later, incorporating a charity can be a relatively involved and sometimes expensive process. However, in my view, these alleged difficulties are unlikely to outweigh the benefits in most cases. Firstly, incorporation is generally relatively efficient and inexpensive. And in any event, any problems with the process are not problems with being an incorporated charity, it's problems with the transition. And secondly, the additional company law requirements which might be imposed on a charity are usually relatively modest. For example, Companies House and the Commission accept accounts in exactly the same form. So the trustees only need to prepare one document. They've just got to file it in 2 different places. That's relatively modest. So that's what the charitable sector is doing and why. But how can your client get involved? Well, as a matter of law, there are 2 key questions for a charity which is considering incorporation. The first is, do the trustees have power to incorporate the charity? And secondly, if they do, how can they actually transfer the assets from the unincorporated charity to the incorporated charity? I'll deal with these questions in turn. Turning to the first question. As with any office holder, the first thing a charity trustee must do before making an important decision is check that they actually have the power to do it. And for incorporation, there are 5 possible sources for the power to incorporate. Generally, the governing document for most modern unincorporated charities gives the trustees the power to incorporate. However, be aware that the document often doesn't use the word incorporate explicitly. Instead, the document might refer simply to transferring assets, it might refer to merging with another charity, or it might simply be part of the dissolving or winding up clause. For example, clause 32 of the Charity Commission's model trust deed allows trustees to resolve to wind up the trust and transfer its assets to a charity with the same or similar purposes. As we'll see later on, that fits the bill nicely for most incorporations. Now, this might sound all very easy and straightforward. Why on earth do I need to do a whole webinar on this? But be careful, even if there's an express clause in the governing document. Firstly, some express winding up powers will not easily allow charity trustees to incorporate. For example, many older trust deeds, the winding up clause says you can only wind up the charity if the purposes can no longer be carried on. This obviously doesn't allow you then to replace the unincorporated charity with an incorporated charity doing exactly the same thing. Secondly, in most cases, a charity will only be able to transfer its assets to another charity with the same or similar purposes. So it's not a free-for-all. You can't completely change tack here. And thirdly, as this is obviously an important decision, the governing document often requires either an enhanced majority, say a 2/3 resolution vote, and or even giving public notice of the proposed decision and inviting consultation from the public. So the point I'm emphasizing is don't go rushing into an incorporation, even if you think your client has an express power in the governing document. But if the trustees don't have an express power in the governing document, you might be able to find an inferred one. Trustees may be able to decide that the transfer of assets is simply an application of the charity's funds in the course of its charitable work. And if that applies, then this can cut out a lot of the difficulties with the statutory route that I'll describe. So you won't have to do things like giving public notice, notifying the commission, or making the decision by an enhanced majority. However, again, in my view, charity trustees should be especially cautious here. Firstly, the decision to transfer all of a charity's assets is clearly an important one, and trustees should make sure that they followed any restrictions or procedures in the governing document. Secondly, and more importantly, the Commission has explicitly warned charities against using this method simply as a way to get around difficult winding up clauses. In other words, if your dissolution clause is unhelpful, the Commission would frown on you trying to use the application method to get around that. So in short, in general, it's likely that this is only likely to be a viable option for charities where three conditions are met. First, the unincorporated charity is a grant-making charity. Second, the charity has no restricted funds. And thirdly, the 2 charities, the one giving the assets and the one receiving them, have similar purposes. Outside of that fairly narrow set of conditions, I'd recommend that trustees take advice on the scope of their specific powers before making a massive transfer of assets. But what if neither option is available? What if the governing document just doesn't help? Well, then the trustees will need to look outside of it to the wider charity law. Now, the key statutory power in this area is section 268, the Charities Act. In a nutshell, this gives trustees of certain charities the power to pass a resolution to transfer all of their assets to another charity. However, trustees can only do this if 5 conditions are met. Firstly, the transfer needs to be expedient in the interests of the charity. Now, this is a phrase that will come up quite a few times in this webinar, so do look out for it. Secondly, any of the purposes of the receiving charity need to be substantially similar to the giving charity's purposes. Thirdly, this cannot apply to designated land. That is, land which is held on trusts that stipulate it must be used for the charity's purposes. Think things like village halls, schools, almshouses, things that are obviously intended to be used by the charity for its work and not simply an investment. Fourthly, this can only apply where the giving charity is an unincorporated charity. Now, that's not a problem for us. We're talking about incorporation, but it wouldn't work if you wanted to transfer assets from a company limited by guarantee to a CIO. Finally, this can generally only work if the charity had income of less of £10,000 or less in the last financial year. However, importantly, this last requirement is waived if the recipient is a CIO. So this gives CIOs an edge over companies limited by guarantee, because larger charities can more easily transfer assets to them than to companies limited by guarantee. Now, there's obviously quite a lot of detail on this slide, so don't worry if you can't scribble it all down or remember it all. You will be sent the slides afterwards. And that's a good job, because the detail just keeps on coming. In addition to those preconditions, there are then 5 caveats that apply after or at the time you're trying to make the transfer. First, the resolution must be passed by at least 2/3 of the trustees, an enhanced majority. Secondly, if the donor has permanent endowment, that is, assets which cannot be spent as if they were income, then the transferring trustees must be satisfied that all of the purposes of the 2 charities are substantially similar. Remember, the general rule is that you only need any of the purposes to be substantially similar. But where permanent endowment's involved, it's all of the purposes. So they must be much closer, the charities. Thirdly, once the resolution has been passed, the trustees must send it and a statement of their reasons to the Commission. Fourthly, at this point, the Commission can do one of 3 things, essentially. Consider the resolution and either outright reject or accept it. Or they might ask the trustee for more information, or they might require the trustees to give public notice of the resolution and then invite representations. Now, why does this matter? Well, the resolution only comes into effect after a delay, and the amount of delay varies depending on what course the Commission takes. If the Commission asks no questions and is simply happy, then it's 60 days after the date the Commission received the resolution. If the Commission asks for more information, it's 60 days after they receive that further information, obviously. And if the Commission asks the trustees to give public notice of the resolution, then it's 42 days after the giving of the notice. That's a bit of an odd one, but the change is between 42 and 60. However, importantly, this is subject to a 120-day long stop. If the whole process takes more than 120 days, then the resolution is voided and never takes effect. So the important point here is, if the Commission gets in touch with you to ask for more information or notice, act as promptly as you can, because if you delay too much, you risk undermining the entire resolution. There are some situations in which charities cannot rely on the Section 268 resolution. For example, as we discussed, if the trustees hold designated land, or if you want to transfer to a company limited by guarantee, but the income for the charity for the last financial year was over £10,000. In situations like that, the last-ditch effort would be to apply to the Commission for a scheme to vary the dissolution powers in the governing document. The Commission can make an administrative scheme under Section 69(1)(a) of the Charities Act. I've put the link on the slide to the Commission's guidance, but in a nutshell, if you're applying for a scheme here, you'll probably need to show 3 main things. Firstly, the change to the governing document is expedient in the interests of the charity. It's that phrase again. Secondly, there's no other easier option available to the trustees to get the power to incorporate. And thirdly, the trustees must have consulted with their stakeholders, people like volunteers, donors, and the public, before applying for a scheme. So in other words, if you're applying for a scheme, you need to tell the Commission why you currently don't have the power to incorporate, why you want it, and who you've consulted as part of the process. One question your clients might have is whether they can simply amend the governing document themselves to introduce a power to incorporate. After all, Section 280 of the Charities Act gives trustees of unincorporated charities the power to amend administrative provisions which relate to the powers exercisable by the trustees or the procedures they must follow. However, the Commission has confirmed that Section 280 cannot be used either to modify the clause which stipulates where the assets go on dissolution, or to allow permanent endowment to be spent. This will likely cover most of the problematic cases for the power to incorporate. So in reality, Section 280 is unlikely to be of any help here. All right, so you've worked out which power your client can use to incorporate, but how do they actually then create the incorporation? Well, the first thing you need to do, obviously, is create the receiving charity. That is, incorporate a company limited by guarantee or incorporate a CIO. Once that's up and running, you can then transfer the assets from the unincorporated charity to the incorporated charity. And there are 5 main ways that trustees can do this. In some ways, the simplest method is the obvious one. The charities lawyers could simply draft a transfer deed which describes all of the property neatly and tidily and transfers it on a certain date. If you go through this route, fortunately, even if you're transferring land, then the restrictions on the disposition of charity land are unlikely to apply. As Section 117.3 confirms, these rules don't apply if the transfer is to another charity for less than market value and the governing document authorises the transfer. So if you're relying on an express power, this might protect you. Similarly, Section 117 has a caveat for transfers by scheme, so you might be able to get around it that way. But for those who don't want to or can't draft their own bespoke transfer deed, there are other options available. The first is called a pre-merger vesting declaration. Now, it sounds complicated, but it's basically the charity law equivalent of the vesting provision in Section 40 of the Trustee Act 1925. And it was introduced into charity law in 2006, basically as a simpler method of transferring assets on incorporation. In a nutshell, the unincorporated charity trustees make a declaration by deed that from a specific date, all of the unincorporated assets of the charity will vest in the incorporated charity. And if the relevant criteria are met, that's it. Now, this sounds quite straightforward. So the obvious question is, well, when can charity trustees use a pre-merger vesting declaration? Well, the first thing we need to do is work out what counts as a merger. And the starting point is Section 306, which defines relevant charity merger. Section 306 gives 2 definitions, but the key one for us is on the slide. It's the first one. In a nutshell, a merger occurs whenever one charity transfers all of its assets to another and then ceases to exist. This is precisely what most charity trustees want to do when they incorporate their charity. So this is the one we need. If this is what your situation is, then the trustees can make that declaration that I described by Section 310, vesting the assets in the new receiving charity. Helpfully in this context, the Commission has prepared a model vesting declaration, which you can access online. I'd strongly recommend that if you're going down this route, you start with the Commission's deed. However, it might sound all too good to be true. There are some caveats. Firstly, a charity cannot use a vesting declaration for certain types of assets. In particular, land which is held as security, a lease which contains a covenant against assignment, unless you've got the landlord's consent, and any property which can only be transferred in books held by a body under some legislation. In other words, this really means stocks and shares and similar assets. Secondly, a vesting declaration cannot transfer the unincorporated charity's liabilities. It can only transfer their assets. Thirdly, a charity cannot use a vesting declaration to transfer permanent endowment unless the recipient is a CIO. So this is another way that CIOs have the edge over charitable companies limited by guarantee. If the company that's receiving the assets is limited by guarantee, then that company will hold the permanent endowment on trust for the existing unincorporated charity, and that unincorporated charity will carry on in existence. Fourthly, transfers of land must still be registered. This is standard land registration principles, and the land registration textbooks recommend that trustees also execute a TR1 form as well as a vesting declaration. Finally, the Commission needs to be notified of the transfer. Section 307 technically says that charity trustees may notify the Commission after the transfer, but the Commission's guidance confirms that they will accept a conditional notification before the transfer has even happened, so that on the day the assets are transferred, you can ring up the Commission, tell them it's completed, and the registration takes effect on the day the assets are transferred. A third option for transferring assets is to invite the Commission to make a vesting order under section 69(1)(c) or 272(4) of the Charities Act. Now, in theory, this power is unlimited in width. However, in reality, the Commission will very rarely exercise it in this context. Essentially, the Commission will only make a vesting order where the charity is unable to execute a transfer itself because the existing trustees have either died or gone missing, or the costs of instructing a solicitor to prepare that transfer would essentially wipe out the charity's assets. Now, that's fairly restrictive. But there's one situation in which charities might want to consider this, and that's if they want to transfer a lease which has a covenant against assignment, because a vesting order does not breach the covenant against assignment, so technically you don't need your landlord's consent. However, the Commission has said that it will still require the trustees to notify the landlord and invite their representations before it would make a vesting order. So in reality here, the trustees of the charity need to weigh up two things. On the one hand, the risk of burning their bridges with their landlord by trying to go behind the landlord's back and get a vesting order. And on the other hand, the cost and time of getting the landlord's consent to an assignment. Because remember, often tenants have to pay to get consent for assignment. The fourth option open to trustees to transfer assets to an incorporated charity is to invite the Commission to make a scheme. When the Commission makes a scheme, it can direct that assets shall be transferred or vested in a new charity. In practice, you're most likely to be considering a scheme if the unincorporated charity holds designated land or functional permanent endowment, or a scheme is the only way that the charity trustees can gain the power to incorporate in the first place. In any of those situations, in my view, it makes sense to apply for the transfer or vesting order in the scheme itself at the time you make the first application. However, to achieve this, the trustee would need to explain clearly in their initial application what they would decide if they had the power, because remember, you're asking for the power in the scheme, and then why you would exercise it in a certain way. In other words, the trustees would need to go through the motions of making a decision, even when they don't have the power to do it, in the hope that the Commission accepts all that information and says, yes, we'll give you the power and make the transfer all at the same time. The final option for transferring assets would be to apply for an order from the Commission under Section 105 of the Charities Act. Now, this appears to be the least common method for effecting a transfer, but it has been known to happen. The Commission has said that it will only make an order where it's satisfied essentially of three things. Firstly, the trustees cannot make the transfer themselves, so there's no express power and they can't rely on 268, for example. Secondly, there's no more efficient way of dealing with the matter, for example, by the Commission giving advice under Section 110, or allowing the trustees to treat this as a de minimis transaction. And thirdly, it's our magic phrase, making an order would be expedient in the interests of the charity. However, on the other hand, the Commission will not make an order where this would either alter the purposes of the charity or contradict an express prohibition in the governing document. However, if the Commission does make an order in your favour, then this would also not breach an anti-assignment clause in a lease by virtue of section 116 of the Charities Act. In the final topic of this webinar, I'll briefly give you my practical tips that you should bear in mind going through the incorporation process, and I'll mention my top 4 tips. Firstly, before starting the process, you should suggest to the trustees that they consider whether they need to update the charity's purposes. For example, incorporation could be the perfect time to cut down obsolete or outdated clauses in old governing documents. In general, as I said before, transferring assets can go to a charity which has substantially similar purposes. So that gives you some room for manoeuvre here in how the purposes change between the sending and receiving charities. However, if the charity trustees want to add entirely new purposes or make more substantial changes, then I'd recommend that you change the unincorporated charity's purposes first before going through the incorporation process, so you don't fall foul of this substantially similar requirement. Also, this is particularly important where permanent endowment is being transferred to a CIO, because in that context, the rules are tighter. The purposes of the 2 charities must be the same so far as is reasonably practicable. So that gives you very little room for manoeuvre in changing the purposes of the CIO compared to the unincorporated charity. So that's why I'd recommend, in that situation, changing the unincorporated charity's purposes first. The second thing to bear in mind is that the incorporated charity should consider granting an indemnity to the trustees of the unincorporated charity. After all, after the transfer, there'll be no assets in the unincorporated charity from which the trustees could be indemnified if something goes wrong. However, there are practical points here. It's common for the trustees of the old charity and the new charity to either be identical or substantially the same. That can give rise to a conflict of interest. And if there are insufficient unconflicted trustees, then the trustees of the incorporated charity will likely need to seek the Commission's approval before it can give an indemnity. To check what you need, the Commission has produced a very helpful flow diagram which you can access using the link on the slides that you'll receive after this webinar. Turning to more day-to-day matters, it's important for the incorporated charity to do various practical things prior to receiving any assets. Obviously, it should open a bank account so it can receive any cash or any donations. It should also consider registering with HMRC for charitable tax relief and possibly gift aid and VAT too. If the unincorporated charity had any employees, you should strongly suggest that they seek TUPE advice on the transfer of employees. Similarly, if the unincorporated charity has a pension fund for its employees, you should strongly suggest they seek pensions advice, because a transfer may trigger an employment cessation event and essentially crystallize the defined benefit scheme. Finally, the trustees, before incorporation, should notify any contractors, stakeholders, or regulatory bodies to ensure that the incorporated charity can hit the ground running immediately and carry on the good work of the old charity. My final point is that unless you're planning to keep it going as a shell charity or a permanent endowment trust beneficiary, then in reality you should be closing down the unincorporated charity after this process. In practice, that will likely involve hosting some kind of trustee meeting at which the trustees approve the final accounts showing a nil balance and then notifying the Commission. The procedure can be found by following the link on the slide. My final tip of the webinar is trustees should make arrangements to keep the old unincorporated charities books for at least 6 years, just to protect themselves in case any litigation arises. Commonly, these books are stored with the new incorporated charity, but that's just one suggestion. There are lots of others, including putting it in deposit boxes, keeping it with the solicitors, or just keeping it themselves. And that brings me to the end of my talk. Thank you very much for listening.
Okay. So we all know that the Charity Commission is the regulator of charities in England and Wales. And their regulatory role means they have to take decisions on a daily basis. And those decisions will likely impact either upon specific charities or upon the sector as a whole. And it's inevitable that sometimes not everyone will agree with those decisions, and they may want to challenge them or to hold the Commission to account in its decision-making process. So that's what I'm looking at today. And I'm going to, towards the end of the webinar, focus on one method of challenge that perhaps is less common than the others. But if you don't know anything about it, it can be really tricky to get your head around in a rush if and when it arises. And that method is judicial review. Now, I think probably a lot of charity practitioners come to the subject, probably with a chancery background. And so public law probably isn't really our friend. And hopefully there might be something useful today that you may be able to use in the future. So if we take it from the top, the Commission's general functions are set out in Section 15 of the 2011 Act. We're probably all reasonably familiar with them, but they are first to determine whether institutions are or are not charities. Second, to encourage and facilitate the better administration of charities. Third, to identify and investigate apparent misconduct or mismanagement and take remedial or protective action. Fourth, to determine whether public collection certificates should be issued. Fifth, obtain, evaluate and disseminate information in connection with the performance of its functions or the meeting of its objectives. And sixth, to give information or advice or make proposals to any Minister of the Crown on matters relating to its functions or the meeting of its objectives. So we can see that those general functions are really wide-ranging, and they will require the Commission to make and take decisions and exercise its various statutory powers all the time. And as I say, it's inevitable that sometimes either a charity or an affected person will not always agree with a decision that the Commission reaches. So the question is, what can you do about that? If the Commission comes to a decision and it affects you or it affects your charity and you don't like it, how can you go about challenging it? Well, broadly speaking, there are three ways that you can do that. So the first is you can ask the Commission to review its own decision through its decision review process. The second is that if it's something over which the tribunal has jurisdiction, you can either appeal to the tribunal if it's something that is appealable, or you can ask the tribunal to review the decision if it's a reviewable matter. And the third option, which is less common, is judicial review. So there are some decisions of the Commission that can only be challenged by way of judicial review, and the tribunal doesn't have jurisdiction over them. So I'm going to try and canter through the first two options and spend a bit longer on the third, because it's probably less familiar. So in terms of Commission's reviews of its own decisions, the decision review process is set down and provided for in the Commission's operational guidance. And the idea behind the decision review process is that the Commission would like the opportunity to review its own decisions before they're challenged in a more formal setting. So whether that be in the tribunal or in the courts by way of judicial review proceedings. And if your decision is being reviewed by the Commission, that will take the form of a reconsideration of the original decision that the Commission made. Usually the review will be done by someone who is more senior than the person who made the original decision, and it will result in a final decision being made. In terms of which decisions the Commission will review, the general rule is if it's something that can go to the tribunal, either as an appeal or review, it's eligible for a Commission review. So we have to look at Schedule 6 of the 2011 Act, and in column 1, which lists all of the decisions that can go to the tribunal for either review or appeal. If you want to ask the Commission to review a decision, you must be one of the people that are listed in column 2 of Schedule 6. So essentially, this is what you need to do to have standing. You need to be listed in column 2. If you want to challenge a decision, or if you want to ask the Commission to review a decision that isn't listed in Schedule 6, so it's something that you would have to have challenged formally by way of judicial review, the Commission will still review those decisions. If you want them reviewed, it's the charity, if it's incorporated, or the charity trustees, if it's unincorporated, who need to ask for that review, or any other person who is affected by the decision can also ask for a review. There are some decisions that the Commission says it won't review. So it won't review something that is already subject to JR or tribunal proceedings, unless you stay those proceedings first. The Commission says it also won't review a decision that it is already reviewed. So you only get one go on a Commission review. You can't keep asking them to think again. And the Commission's guidance says that it won't offer a review of a decision to grant consent to a charity. And it says that's because the Commission is not able to quash or set aside the decision, as it has no statutory authority to do so. Now, I wonder how well that actually sits with the powers at 337 sub 4 of the 2011 Act. So if you're not familiar with it, 337 sub 4 is the provision that enables the Commission to discharge an order where it's satisfied that it made that original order either by mistake or as a result of a misrepresentation. So we can see that the Commission does actually have, albeit a limited power, but it does have a power to set aside its own decisions. Okay, so if you want the Commission to review its own decision and you are one of the people listed in column 2 of Schedule 6 and you have standing to ask for that to happen, you must make that request within 3 months of the date of the original decision. Practically what this means is probably your decision came by way of an order or decision notice, so it'll be 3 months from the date of that document. Curiously, for a review as well, the Commission says that it will consider all existing relevant information, but also any new information or legal advice that it received in the process. So a little bit unusual for a review. The Commission aren't confining themselves to looking at the decision through the lens of the decision maker at the time and what the decision maker knew at the time. They're saying that they can take into account everything, including new information that's come to light since the date of the original decision. Once you've been through the review process, you'll get a decision notice, and that notice may either uphold or overturn the Commission's original decision. And the guidance says that in that decision notice, you will get an explanation for the final decision. So I would take that to mean that you're going to get some reasons as to why the Commission has reached the final decision that it has. So turning then to your second option, so the option of going to the tribunal. The tribunal's jurisdiction is set out in section 315 of the 2011 Act. And the tribunal has jurisdiction to hear and determine appeals and applications that are made in accordance with section 319 to 324. So these are reviews of reviewable matters and appeals, or any matters that may be referred to the tribunal in accordance with sections 325 to 331 by either the Commission or the Attorney General. So the Commission can refer a question to the tribunal if it arises in relation to the exercise of its functions or the application of charity law. And the Attorney General can make references to the tribunal on the question of the operation or the application of charity law. So if you're thinking about challenging a Commission decision, you're falling pretty much squarely within category A, so your appeals and your reviewable matters. So your appeals then are dealt with in section 319 of the Act. And you can appeal any decision, direction, or order that is listed in column 1 of Schedule 6, unless it's a reviewable matter. If it's a reviewable matter, we'll deal with what those are in a moment, you're stuck with a review by the tribunal. You can't appeal that decision. If you want to bring an appeal to the tribunal, you must be one of the people, again, listed in column 2 of Schedule 6, so essentially your standing test, and you must name a Commission as the respondent. And because it's an appeal, the tribunal can consider afresh that original decision, and it can take into account evidence that the Commission did not have in front of it when it took its original decision. So you're not just restricted to looking at the question or the decision through the lens of the original decision maker. If the tribunal is inclined to allow your appeal, it can exercise any of the powers that are listed in column 3 of Schedule 6, or at least the ones that are listed next to the type of decision that you are having, that you are appealing. Those powers are quite wide-ranging, so they range from quashing orders, remitting the decision back to the Commission to take the decision again, and in some cases the tribunal can also substitute its own decision for that of the Commission. So reviews then, there are a small number of Commission decisions that cannot be appealed, but over which the tribunal still has jurisdiction. and they can only be reviewed. And so those reviewable matters are set out in section 322. Again, if you want to ask the tribunal to review the commission decision and it is a reviewable matter, you must be one of the people listed in column 2 of schedule 6, so your standing test, and you name the commission as a respondent or as the respondent. And because it's a review, when determining the application, the tribunal has to apply the same principles that the High Court would apply if it were an application for JR. So you're looking at the decision through the lens of the decision maker at the time and what they knew at the time when they made their decision. And again, similar with appeals, if the tribunal is inclined to allow your application, it can exercise any of the powers listed in column 3 of schedule 6. And so those are the powers ranging from quashing orders, remitting the decision back, and perhaps substituting the decision for its own, probably less likely in the case of the reviewable matter. Okay, so I've cantered through those ones. I want to spend a little bit more time looking at judicial review. And now I do accept that there are few decisions of the Commission that can be judicially reviewed. And as I said, I suspect most of us come at Charities from a chancery background, and we're probably fairly unfamiliar with JR and public law principles. But the problem with JR is that the time limits are really, really tight. And it's almost certain that you will be in a rush when you're trying to issue your JR. And the process can be really tricky to get to grips with. And there are lots and lots of procedural pitfalls that you need to be aware of. So which decisions of the Commission can you JR? So pretty much anything that's not listed in Schedule 6. So Schedule 6 of the 2011 Act, column 1, set out all those decisions over which or all the matters over which the tribunal has jurisdiction. You want to challenge something that is not on that list, you're going to have to do that by way of a JR. You can't go to the tribunal. So just to prove that these aren't the rarest of the rare, some examples. We know that you can challenge by JR Commission guidance. The Independent Schools Council case is on that point exactly. Something that I've come across and is why I've had to get to grips with JR. If you want to challenge a Commission decision to discharge an earlier order, so if you want to challenge a section 337 sub 4 decision, that has to be done by way of JR. And when I was reading last night, something that occurred to me is if you want to challenge an official warning, that probably has to be done by way of JR as well. So you're never going to, it's probably not going to be your first port of call. I completely accept that. But you may come across a situation that you want to challenge and it isn't there in Schedule 6. So if you are JRing, what are the remedies that you might be asking for? So your remedies are set out in section 31, subsection 1 of the Senior Courts Act 1981. And actually section 31 in general was the section that you need to go to in the Senior Courts Act to look at the powers of the High Court and what it can and can't do on an application for JR. So the remedies that you're going to be asking for in a JR will be either a mandatory prohibiting or quashing order, or perhaps a declaration or an injunction. When you're challenging Commission decisions, you're probably going to be looking for a quashing order. You probably want to get rid of the decision that the Commission has made if you don't like it. Or it might be that you're asking perhaps for a declaration that an order does stand or an earlier order stands instead. Crucially though, if you are JRing, the court cannot substitute its own decision for that of the Commission. So the High Court does have the power to substitute its own decision for that of a decision maker if the original decision maker was either a court or a tribunal. And so that's the effect of section 31 sub 5 and sub 5a. And obviously the Commission doesn't fall into that category, it not being a court or a tribunal. Okay, so I promised you lots of procedural pitfalls. What of the procedure of JR then? So JR is essentially a Part 8 claim, heavily modified by Part 54 and Practice Direction 54A. And also it's got its own special claim form. It's an N461 claim form. And the important thing to remember with JR claim forms is when you issue that claim, what you're doing is you're asking for permission to bring a JR. You can't just judicially review the decision of a public body. You have to ask for the court's permission to then go on to the substantive claim. If you want to issue your JR, you must put your claim form in promptly, and in any event, no later than 3 months after the grounds to make the claim first arose. So promptly, and in any event, no later than 3 months. And so that's what CPR 54.5 tells us. And 3 months can actually be really short. By the time you've got your order, you've thought about it for a little bit, you've decided you don't like it, you can't quite put your finger on it, charity goes and gets advice. It may also be that the charity trustees have to meet and resolve that they are going to challenge a particular decision. You can see that these 3 months are going to be eaten up pretty quickly. You also have to factor in time for your pre-action letter off to the commission. 3 months will go very, very quickly. So it's really important to keep an eye on that 3 month time limit. And also remembering that that 3 month is a long stop. Really, what you should be doing is doing it promptly. CPR 54.6 and paragraphs 5.6 to 5.9 of the practice direction. I'm going to look in more detail at the next slide. But broadly, that's going to be that sets out the contents of the claim form and the documents that you need to put in with your claim form. Essentially, what you're doing when you issue a JR is you're putting before the court a claim bundle. And in this new electronic world, that has to go in electronically. It needs to be indexed with hyperlinks, and it needs to be paginated. The admin court has got very strong and strict guidance on what it wants its bundles to look like when they go before the judge, and it's worth having a look at that to make sure that your bundle complies. Okay, so CPR 54.7, something that is different, I think, to the tribunal is that you have to remember as the claimant, you are going to be serving the claim form. So in the old days, you would have taken your claim bundle up to the desk, they would have stamped it, and then you would have popped everything in the post off to the defendant, in this case, the commission. Now you email it across to the court office and it will come back with an electronic seal. You have to serve that, and you have to do that within 7 days of issue and file your certificate of service to show that you have done that. You should get a covering letter that tells you that, but if you don't, be aware that is your responsibility. The court will not do that for you. And then once you have served your claim on the defendant or the proposed defendant, so in this case, the commission, they would have 21 days to serve an acknowledgement of service and their summary grounds of defence. So what's going in your claim bundle? Quite a lot, actually. So as I said, CPR 54.6 and paragraphs 5.6 to 5.9 of the practice direction are where you need to be looking. Unsurprisingly, the first document that goes in your claim bundle is your claim form, and it must state that you are requesting permission to proceed with the JR claim and the remedy that you are after. The other thing to keep an eye on and to consider is whether there are any interested parties in your claim. So is there anyone else other than the charity and the commission who are affected by this decision? If there is, you need to name them as an interested party, and you then need to serve that claim on them as well. They don't have to take part, but they may choose to take part in the proceedings if they want to. The other thing that you need to put in, that's really, really important, is your statement of facts and grounds. So your statement of facts and grounds is essentially your pleading. It's more discursive than a Part 7 pleading, and it's not quite as formulaic. It looks a lot more like a witness statement. And it's different to your regular sort of pleadings in that you do cite law, you do cite your case authorities and deal with the principles, and you can cite statutory authority. You wouldn't ordinarily expect to see those in your usual litigation pleadings. The other things that need to go in your claim bundle, any written evidence, the copy of the order or the decision that you are seeking to challenge, any documents upon which you propose to rely, and also any statutory material. And so actually you need to put quite a lot of thought into your claim bundle, again, eating into your 3 month time limit. You need to make sure that everything's in there that you could possibly want in there, because it's actually quite difficult to get anything else in prior to the judge making a permission decision. So you need to think really, really carefully about your bundle and make sure everything's in there. As I've already mentioned, you will be filing this as an indexed and paginated bundle with lovely hyperlinks and making it really user-friendly. It's your claim bundle that's going to go before the judge, along with the acknowledgement of service and the summary grounds of defence. Something else you might want to pop in is a reply. So you may wish to reply to those summary grounds of defence. You don't have to. The same rule applies as it does across all other litigation. Your reply is completely optional. In some cases, it's advisable. But if you want to put it in, you need to put that in pretty quick, because you need to make sure it gets on the court file and it goes before the judge with the claim bundle and the other documents. And if you are putting in a reply, obviously you need to be serving that on the defendant, so in this case, the commission, and any interested parties. Now, the court will generally consider your permission application on the papers and it won't hold a hearing. If you are lucky and you get your permission, the court will probably at the same time issue directions taking you all the way through to the final hearing. The directions will probably be something along the lines of the defendant to serve full defence grounds. You would then perhaps get the chance to reply, and also provisions for the filing and serving of evidence. If permission is refused, then as the claimant, you can request that the decision is considered again at an oral hearing. And so this is what you might hear called either a permission hearing or a renewal hearing. You can only have one of those if your claim was not certified as totally without merit. And if you want one of these hearings, if you're in a position where you need one and you want one, you must ask for it within 7 days of that permission decision being served on you. So you've got to be really quick, and you have to make a really quick snap decision. It is perfectly possible, if you are challenging or you're trying to bring a JR on multiple grounds, that you might get permission on some grounds and not on others. If you find yourself in that position, that's okay, because what you can do, again, as long as they're not totally without merit, you can ask for an oral permission hearing on the grounds on which you do not get permission. Most likely what will happen to you then is you will have that little permission hearing at the start of the substantive JR hearing. So you have what we call a rolled up hearing. It all happens on one day and in one event. And perhaps one thing as well, just to note on the point of permission decisions, the court will serve the order granting or refusing permission. You as the claimant don't have to worry about that, contrary to the position with claim forms. Okay, so it's quite easy to identify that something doesn't smell right or something doesn't feel right. It can be a lot harder to put your finger on perhaps legally what's going on and why something's wrong. When you are bringing a JR, no matter who it's against, whether it's the Charity Commission or someone else, it's going to be your usual public law grounds of challenge that you need to have 2 eyes firmly on. And whilst the old 3 Lord Dick Block categories are somewhat unfashionable now, or you can split your JR grounds down to 4 things. You're either looking for illegality, irrationality in the decision making, procedural unfairness, or a breach of a legitimate expectation. So if you want to try and allege illegality, the sorts of things that you are looking for is whether a decision has been made ultra vires. So did the defendant, in this case the commission, have the power to make the decision that it did, or has it acted out with the scope of its powers? Has it exercised its powers for an improper purpose? Has it frustrated, or in exercising its decision-making powers, has it frustrated the purpose of the empowering legislation? Those are the big ones that you're looking for illegality. In terms of irrationality, this is where Wensbury reasonableness comes in. So has the commission made a decision that's so unreasonable that no reasonable decision maker could have come to it? And you might also ask if the decision maker has taken into account either irrelevant matters, or if it's failed to consider relevant matters to which it should have had regard. As to the other 2 remaining grounds, procedural unfairness, you might ask if the decision maker, so in this case the commission, had a duty to consult either the charity or the affected third party. There may be an express statutory duty in some cases. If there's no express statutory duty, you might be able to argue that there was a common law duty for consultation. Even if there is a duty to consult and the commission has done that, the next question would be, well, have they done that properly? Have they followed the Sedley criteria? Same with the duty to give reasons. Is there a duty to give reasons? Have those reasons been given? And also you might think about looking at the principles of natural justice, so whether that be bias or failure to hear an affected party. For legitimate expectation here, what you're looking for is, has the Commission represented that it will adopt a particular procedure? And then has it adopted that procedure, or has it done something different? Okay, so one of my big points that I think you ought to look out for, I think there are three really, and they're all procedural and they're all time limits. So remember, you must issue that claim form promptly and in any event no later than 3 months. And really you shouldn't be trying to run it to the 3-month deadline. You should be looking to do it promptly. Something I didn't flag earlier that I perhaps should have done, the parties cannot agree an extension to this 3-month deadline. The court can grant one, but the parties can't agree one. So you really, really have to keep 2 eyes firmly on that 3-month time limit. The second point and the second time limit that I really think you need to keep an eye on is making sure that you serve your claim form within 7 days of it being issued. And the third one, and I think probably the tightest one of them all, is if you do not get permission and you want to request that renewal hearing, you must do that within 7 days. You really, really have to do that. If you don't, you're absolutely stuffed and your claim has gone. You have to make a pretty snap decision. So it's worth thinking about this decision long before the permission decision comes out. And so that is me, and that is JR. I will stop sharing my screen.
Thank you very much, Natalie. Now, there are 3 written questions for me, which I'll address now. And while I'm whittering on, if you have any questions for Natalie, please do type more into the Q&A box or raise your hand. So the first question comes from Rebecca, and she says, Matthew, you suggested that if the charity wants to change its purposes, the unincorporated charity does this before the asset transfer. What is your view on making the asset transfer and then changing the purposes of the corporate charity at a later stage? Now, Rebecca, in my view, that's a very fair suggestion, but I would be cautious about doing it that way around. So in your hypothetical, what the trustees are doing is they're transferring assets to a recipient charity, knowing that that charity is then pretty much immediately going to change its purposes. In other words, the trustees know that in future, there might be a breach of the similarity rule for the purposes. So in my view, there's a risk that in that situation, when you come to changing the incorporated charity's purposes, the Commission may view it as some kind of fraud on a power or way of getting around a restriction in the governing document or statute, and that might cause problems. On the other hand, if you change the unincorporated charity's purposes first, then you can make the 2 charities have literally identical purposes, and there can be absolutely no issue at all doing it that way round. So that's why I suggested it that way. Rebecca then asked me another question. She said, Matthew, are there any issues or pitfalls with using a bespoke deed of transfer to transfer permanent endowment? Now, there's sort of 3 points really that relate to bespoke deeds, and none of them really specifically relates to permanent endowment. So the first practical point is that bespoke transfer deeds are likely to be more expensive than the other methods, because obviously you have to pay someone to draft it from scratch for you, whereas, say, applying for a scheme is free and the model pre-merger vesting declaration is free. Secondly, there's obviously a risk that if you use a bespoke document, you might get something wrong, whereas that doesn't apply if you use automatic templates or statutory provisions. And the third point I'd make, which isn't really to do with what you were saying, but it does relate to this issue. Section 311 of the Charities Act only applies to pre-merger vesting declarations. It doesn't apply to bespoke transfers. And what this section says is, once a merger has been put on the register of mergers, any gift to the old charity automatically takes effect as a gift to the new charity. So if you have a regular donor who's forgotten to update their bank details or forgotten to update who they must send their donations to, if you're on the register of mergers, it's not a problem. It automatically goes to the new charity. Whereas if you use a bespoke transfer, you need to find some kind of way of making sure that the old gifts are legitimately passed on and not automatically refused. And that doesn't really go to permanent endowment. I don't think there's any specific issues here, apart from the cost and the potential to get it wrong. But I wanted to mention it because it's a generally useful point that didn't come up in my webinar. The final question is from Hazel. And she basically asked about resources. So will this be available? Will we get the slides? Any books on incorporation? So Hazel, the slides will be sent to you shortly, maybe this afternoon or later. This will also be put up on our YouTube channel. So if you just search for Radcliffe Chambers on YouTube, you can then get access to all of our previous webinars, including other charity webinars. But specifically on the point of incorporation, I'd recommend 3 sources. One of them's free, 2 of them you probably have to pay for, although I note that you work for a charity, so you might get a discount. So the free source is the Law Commission's 2018 report on technical issues in charity law. It's called report number 375. And in my view, chapter 11 really nicely sets out the 2 different stages of incorporation, the power and then the transfer, and goes through the options very clearly. Now, there are links to that in the slides, which you'll get, or you can simply Google it. If you have access to it, I'd say the 2 best sort of legal sources are on practical law. And there's Charity Incorporation Overview and Charity Incorporation Key Issues. So those are the 3 things I'd recommend that anyone who wants to look into this themselves starts with. Joseph, I'm not going to read it out in full because it's quite a chunky question, but in a nutshell, he's asking about Section 280, which is the power for trustees of unincorporated charities to amend their administrative provisions. And he says, what if the unincorporated charity, say a trust, intends to retain a nominal amount of cash after the transfer? So let's say they've got £10,000, they transfer 9,900 and keep 100. That wouldn't technically be altering how the charity's property can be distributed on dissolution. He said, would that be a problem? And you're exactly right, Joseph, that wouldn't technically come within the 2 things that the Charity Commissions say they don't like. But I would recommend caution here. When the Law Commission were discussing this particular provision of Commission guidance, I can assume this was with the discussion of the Commission, the Law Commission phrased it more broadly. They essentially said you cannot use the Section 280 power to frustrate any kind of power in the governing document, or to essentially go behind the substantive rules that exist. So I think although you would technically not be altering the powers of distribution on dissolution, what you're effectively doing is trying to get around those restrictions. And I think you've got to be wary before trying to take a technical approach like that, because saying to the Commission, aha, we retained a tenor, it's not technically being dissolved. I think it's more the spirit of the rules than the technicality that you've got to be wary of here. That's certainly how the Law Commission viewed this provision, and I'd agree with their analysis on this point. I don't think there are any other questions for either of us. If you do have anything you think of afterwards, please do drop us an email. You can find our contact details on the website. And we hope to see you again at another Radcliffe Chambers Junior Programme seminar, potentially with wine and nibbles. Fingers crossed for something soon. But thank you very much.
Thank you.